case on this morning's docket, case number 112959, State of Kansas v. David E. Parker, Jr.
May it please the court, Christina Curls of the Appellate Defender Office for Mr. Parker. I would request 3 minutes for rebuttal.
3 minutes is granted.
Just the brief procedural background. In this case, Mr. Parker was convicted by a jury of possession of cocaine, fleeing and attempting to elude, driving with a suspended, as well as two traffic violations, failing to use a turn signal, and driving without his headlights. He was convicted of those counts. He appealed both his convictions and his sentence. On appeal, we challenged sufficiency of evidence for fleeing and eluding, as well as the district court's denial of Mr. Parker's motion to suppress. Court of Appeals, we also had a challenge to a peremptory strike of the state. We won that issue and it wasn't cross-appealed, so it's not at issue today. What was petitioned were the first two issues, the sufficiency of evidence, as well as the motion to suppress, and then the Ivory Apprendi issue with regard to Mr. Parker's sentencing. For argument, I'd like to focus my argument on the second issue, the motion to suppress, unless the court has questions on the other issues. The primary issue surrounding the motion to suppress is whether or not the duration of the detention and seizure of Mr. Parker and his vehicle exceeded the scope of the stop. What happened in this case is Mr. Parker was being followed by an unmarked police car. He pulled over into a Dillon's parking lot because he had testified, I believe, that he had heard about some scam with people pulling people over in unmarked cars and then robbing them, so he wanted to make sure he was parked in a public place. Pulled over into the Dillon's parking lot. He was arrested for fleeing and eluding. They found out that he didn't have a valid driver's license. So he was arrested, placed into custody, and put in the back of the patrol car. At that point, the officer... Yes, sir.
When he exited the car, did he lock it?
I believe he did. I'm not 100. I know that the officers had to crawl in through the trunk to gain access to the car once they did commit their search.
That was going to be my question. If the car was locked, how did they get in? But...
Yeah, in rereading information in order to prepare for today, the officers did crawl in through the trunk of the car and unlock the car so that the search can be conducted once it actually was conducted.
I think under the facts of this case, it's pretty clear that what he did was legally park the car in the parking lot. I mean, it wasn't out in a pathway or anything. Legally parked, locked it, walked up to the officer and said, "You have to have a search warrant to get in the car."
Yes.
And then they went through the rest of the
Yes. Yes. They placed him in custody in the back of the patrol car.
They arrested him.
They arrested him, placed him in custody in the back of the patrol car. One of the officers did a walk around the car and didn't see anything illegal in plain sight, so he called in a drug dog. The drug dog, it's not entirely clear how long it took for the drug dog to get there, but essentially the search was conducted an hour and 20 or 40 minutes after Mr. Parker was placed into custody. So there was a bit of a wait for the drug dog.
There wouldn't be, what the district court said in its order was it took an hour or so.
Yeah.
Let's just accept that.
Yes.
And there wouldn't make any legal difference in this case if it was an hour or so and an hour and 20.
No.
Okay, so
no.
let's just live with that.
Okay. Because the issue here is that the detention, primarily of the vehicle, exceeded the scope of the purpose of the stop. He was originally...
Why does that... It seems like we're cross-pollinating legal theories here. Once he's arrested, the mission of the stop is over with. They're done. He's arrested, he's in the car. And so now I think you've got to move over to demonstrating that the vehicle was seized don't you? Isn't that the next step in the very first step in the analysis before we talk about anything else? And I'm having difficulty determining that the vehicle was seized. He parked it legally, and the police walked away from it. They didn't assume control of it.
I would argue that the vehicle was seized because they knew it was registered to his wife and they never gave the wife the opportunity to take control of it.
So let's talk about that. Is there anything else that contributes to the notion of seizure other than they didn't affirmatively notify the owner?
Well, they seized the vehicle when they initiated the stop to begin with. By detaining Mr. Parker while he was in his vehicle, that detention of him necessarily involved the detention of his vehicle.
Well, but if they arrest him, all load up in the cars and drive away, they haven't seized the vehicle.
Right, which is
And
the
so
issue.
so the fact that they're just hanging around there, how is that a seizure of the vehicle? I mean, did they attempt to stop anyone from assuming control of the vehicle? Did they interfere in any way with the vehicle?
The issue is that they didn't give anybody the opportunity to, so it
So
was
let's focus
in
on
effect
that.
a seizure.
Let's focus on that. Did anyone ask them to notify the owner of the vehicle? I don't see that in the record. I don't see where your client asked that the police...
I don't see that either, but he did make
Okay,
it...
so no one asks what requires the police officers to notify the owner that car is legally parked in the grocery store.
I would argue that the case law that requires the scope of a detention of a seizure of evidence, of a seizure of a person to be limited in scope to the reason of the seizure would require that.
That's about the people, not the automobile, isn't it?
I would argue that they're both founded in Fourth Amendment principles.
There they are. They've been separated here.
But
The vehicle and the person have been separated at the time of the arrest, right?
They had, but I would argue that both concepts, seizure of property and seizure of people, are both founded in Fourth Amendment principles. So the same rationale that requires the seizure to be limited to the purpose of the original detention would apply to either one.
The detention had ended, as my colleague has pointed out, and now we have an arrested individual separated from the vehicle.
I would argue that the detention hadn't ended. I mean, he was obviously still being detained because he was in custody, and the detention of the vehicle hadn't ended because they were still there. They were still there. They called a police dog to come out and do a sniff. They kept everybody there for the purpose.
What if they had come back the next day with the drug dog and the car was still sitting there?
I think that would be a completely different situation.
Okay, so how is it different other than the time elapsed?
I would say that it was different because it would be likely in such a situation that at that point the defendant would have had the opportunity to contact someone to come and pick up the car. Because once he was
He's
booked,
telling you to assume it's still sitting there.
assuming it's still sitting there, if he had had the ability to contact someone and they chose not to do so, that's a different question entirely than not even giving them the opportunity to do so.
With regard to the person, we talk about whether a reasonable person would feel free to ignore the police and go about its way. Obviously, the law enforcement can't tell the car you're free to go.
Exactly.
So does it make any difference whether the defendant would have reasonably thought that he could arrange for the car to leave the area without risking somebody getting shot? I mean,
I think,
you understand what I'm saying?
Yeah, I do understand
The only way you get there is if the operator of the vehicle that was seized must reasonably believe that the car was released from seizure when he was placed in the car. If that's not required, then I think you've got problems, as was the questions have indicated.
And I think that is a reasonable requirement with the seizure of evidence as opposed to the seizure of person. If he believed that he had the ability despite the fact that he obviously didn't have the ability because he was handcuffed in the back of a patrol car at that point, to arrange someone else to come pick up the car, that would be a different story. It would also be a different story if they had decided to seize the car as the instrumentality of the crime and have it towed to impound. That wasn't the situation in this case. They kept the car there for the express purpose of bringing in a drug dog to look for evidence of a crime that was in no way related.
How did they keep the car there? What specifically did they do to keep the car there? Because you've said things they didn't do. What did they do? Did they put up police tape? Did they put up car, barriers, blockades?
I don't know of anything that they specifically did, but it amounts to the same thing by not allowing Mr. Parker to call his wife to come pick up the car, and by them not notifying Mr. Parker.
Did they not allow him to? I mean, is there evidence that suggests he tried to do that and they didn't allow him? I mean, it sounds like you're mixing up, to me, affirmative acts versus just a failure to do something that you think they should have done.
You're promulgating a sin of omission.
By placing him in custody and not taking him to be processed, to be booked into the system, to get his phone call, assuming that that's something that actually happens and isn't just on TV, by not following that process once he was actually arrested, they prohibited him from having that ability to do so.
Well, we talk about, there again, what a reasonable person would believe, and we talk about the presence of more than one officer. We talk about whether the lights were on and that sort of thing. So convinces that the circumstances were such that a reasonable person would believe that their vehicle was still seized.
Would argue that Mr. Parker, in his position, would believe that his vehicle was still seized, partially because they were all still there. He was still sitting next to his vehicle in that parking lot in a police vehicle with lights and sirens going. I believe other police vehicles were there as well. I don't remember exactly whether or not or how many police vehicles were in the area. They'd asked to search. He told them they needed a warrant. The officer did a walk around and then called to bring and kept them there so that a drug dog could be there. A reasonable person in Mr. Parker's situation would believe that they had control of his vehicle.
Would that be true of the vehicle that was parked next to Mr. Parker's car? I mean, all those circumstances are identical for that other car.
They're not identical because that other car wasn't pulled over by the police to begin with.
Wasn't
The show of
seized
authority
initially.
wasn't for that other car, whose owners presumably
I thought your
grocery
argument
shopping
was
inside of
that
Dillon's.
another person could have come along and taken the car home or taken the car elsewhere, but that the circumstances surrounding the car would have caused that reasonable person to not believe that they had the authority to do that.
But part of the circumstances surrounding Mr. Parker's car is the fact that he was pulled over to begin with.
That there was an
That doesn't
initial,
apply
You're
to the
saying
other
the
car.
initial seizure has to terminate.
Exactly.
Yeah, when we talk about people, we talk about attenuating the initial seizure. And you're trying to say there was no attenuation of the seizure of his property because of the circumstances.
Correct.
I assume, because there's nothing in the briefing and otherwise, that the record is silent about what the time process would have been if they had followed the procedure that you're talking about.
It is not clear exactly.
So are you asking us to speculate that this detention was longer than it would have been if they had allowed him to make a phone call, which I assume would have been after booking and there would have been I assume a process that would have been done before that would have happened, but I don't know that the record even tells us that, does it?
My argument is because the police illegally extended that detention. We don't know whether or not.
That gets back to the
And
attenuation.
if they had, for example, if the police officers had called his wife or taken him directly to booking and he was able to call his wife and she didn't happen to beat the drug dog to the parking lot, it would be a different situation because then they would have actually released the detention of the vehicle. They would have actually the vehicle would no longer have been detained as a part of the initial seizure. That wasn't the case in this situation. It wasn't the situation where the police officer says you're free to go, but I have one more question. This was a situation where the police officer never tells him he's free to go and continues asking questions beyond the scope of the stop. Only in this situation it applies to property rather than a person, but the Fourth Amendment protections apply equally to both. And that's what our argument is. It's that the seizure of the vehicle never stopped, and it went beyond the scope of the purpose of the stop, specifically so that they could find evidence of crimes not related to the purpose of the stop. And to allow that would erode the protections of the Fourth Amendment, and specifically the protections of Arizona v. Gant, which requires searches to be related to the reason for arrest.
Just to get this off as the arguments have evolved from the Court of Appeals to us, as I see it, you don't contest that there was probable cause for the search once the drug dog alerted.
Yeah, the case law is clear that once the drug dog alerts, that can establish probable cause.
So what we're focused on is what happened before the drug dog showed up.
Yes, sir.
Okay.
Unless there are other questions, I would ask this court to reverse Mr. Parker's convictions for the reasons stated in the brief and the petition.
I see none. Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. I will also limit my arguments to the second issue unless there are questions regarding the sufficiency issue. It's our position that I don't really have a lot to add to the Court of Appeals decision. We feel that they got it right here.
Then let me interrupt, because it didn't seem like the Court of Appeals talked about what I was talking about, which was whether there was a seizure initially of the vehicle. That once we've got this arrest, no one's meaningfully interfering with the vehicle during the time the officers are sitting around waiting for a dog to show up. In other words, the owner didn't show, no one tried to get into the car or take the car away. No one even approached the car. So my question to you is, was the vehicle seized?
And when you asked that question earlier to opposing counsel, I thought of that because the Court of Appeals kind of skips over that, and they talk about seizure and instrumentality of a crime.
Let's be realistic here. If his wife had been in the passenger seat and he had jumped out and went over there and said you can't search, and the wife had got underneath the wheel and started to drive off, she wouldn't have been able to leave with that vehicle.
No, but that would be different.
Well, I'm saying that they stopped the car, and the car couldn't leave the premises at least before they made the arrest. Would you agree with that?
Yes,
that no one could have taken that car away while the police were there, at least until they made the arrest.
But with Justice Biles' question, I guess the question is when we think the arrest occurred. I believe the arrest, from the facts and the record, occurred quite quickly upon him stopping and parking the vehicle and the officer arriving on scene and making contact with defendant.
It doesn't really matter. He was under arrest the second they threw him in the back seat of the car.
Absolutely. And that's very clear here. He was arrested. And I
what
think
we're struggling with is what was the status of the car between that point in time and the arrival of the drug dog. Your opposing counsel says the car was still seized. What's your counter argument?
Well, I understood the initial question from my colleague was the car seized? Was it ever seized? And then we need, if you say yes, then the next step is when did the seizure terminate? But I didn't hear you as agreeing that the car was ever seized.
It's legally parked by defendant. He locks it. At that point,
No, let me start again. When an officer follows a car, turns on red lights and siren to pull the car over and makes a vehicle stop, which is what we call it,
Yes.
a traffic stop, vehicle stop, is the vehicle seized or just the driver?
I guess I would say I agree with the Court of Appeals determination that this was a seizure here.
Because the vehicle's an instrumentality of the fleeing and eluding? Is that the...
That's-
Wait,
that-
I'm sorry. You said there was a seizure at the beginning of the traffic stop of the vehicle as well as the person. That was the original question.
Yeah.
Yes or no on that?
They are both stopped. Defendant is arrested. So I would agree that it could be determined that that's a seizure.
Okay, I'm sorry. I
No,
interrupted
that's
Justice
fine.
Rosen.
And the reason is that because the vehicle is the instrumentality of the traffic,
Of the
crime?
flee and elude.
of the
I
fleeing
mean,
and
at that point, all we have is the flee and elude, and that's what he is arrested on. Now, while he was committing,
That still doesn't make sense. Let's say it ended there. The vehicle, the means by which the fleeing and eluding took place, doesn't become evidence, does it? I mean, it's not. It's rare that I don't recall an instance in a traffic offense where the vehicle is brought into court as evidence.
I've had a case, but it was different. But
But and that seems to be what the Court of Appeals used to justify the seizure. It was the instrumentality of the fleeing and eluding, which that doesn't make sense to me.
well, and I don't know that it necessarily has to make sense, but it is evidence of that flee and elude. He's in the vehicle. He talks about in his testimony at trial about not knowing it was an officer. He, admits to why his lights were off. He really doesn't indicate that he was fleeing and eluding. He never testifies that he was going as fast as the officer does. But this car is an instrumentality of flee and elude, because to flee and elude, you have to be in a vehicle. So does it seem odd? But yes, it is evidence of that crime
So
that
did
he
it
was
remain
arrested.
seized all the way then, till the dog showed up? Did it remain seized all the way until the dog showed up?
Did it remain seized until the
'cause
dog showed
that
up?
was my original question,
right.
and then we backed up. So I still want an answer to that. Was it seized in the time period between his arrest and placement in the police car and the time the dog arrived? Or was it just sitting there in a lawful parking place and anybody could have walked up and driven away with it?
It was sitting there in a lawful parking lot, lawfully parked.
Is that enough to break the seizure of the property?
See, this was never well developed, this exact argument below, and so I think that's why there are all these questions about
But
this
they're critical
vehicle.
to the analysis. So if the record's lacking, what does that tell us? The later search is violation of the Fourth Amendment because it's the state's burden to demonstrate an exception applied?
No, I think that it could also tell you that this was not raised by a defendant in the trial court. The specific argument
The
of
defendant doesn't bear any burden once there's a motion to suppress, does it?
true, but they do have to raise their claims when they file their motion. They do need to raise the claims of why it is they feel the evidence should be
Have we
suppressed.
said that? That a defendant has to be specific about how the Fourth Amendment was violated rather than just saying, I moved to suppress because my rights under the Fourth Amendment were violated?
I believe the statute indicates that there is some specificity that needs to be pled. Of course, the statute would speak for itself.
So the answer
But-
to my original question is we don't know, right? We don't know what the status of it was between those 2 points, and the reason we don't know is that the defense did not meet whatever burden it bore in the district court to build a record that would tell us what was going on.
Well, what we do know is that the district court ultimately found that the vehicle was seized.
The entire time. I'm still trying to zero in on the part that I think is critical to the analysis on the search.
I believe we can determine that the district court found it was seized the entire time because they make that finding that the vehicle was seized. And to
You said make that finding. I mean, isn't that a legal question whether the vehicle was seized? It's not a fact finding, is it?
Well,
There aren't any facts in dispute in this whole thing.
Let me back you up, if I could, even further into theoretical territory. When you have a flee and elude situation, is there ever even a traffic stop effectuated? I mean, I get that we have a law enforcement officer attempting to make a traffic stop and even initiating one, but the
I would
stop
agree.
never, or at least arguably, doesn't occur, and then you have an arrest. So was there ever a traffic stop at all?
Or is there a difference between a capture and a traffic stop?
Yeah. It would have been a traffic stop had he stopped for
Right.
the headlights.
Yeah, obviously, and I would agree, it starts with the attempt to initiate a traffic stop. And then based on defendant's actions, it becomes an attempt to flee and elude.
But if there's
and
no
then-
stop, that's at least that legal hook for the idea of a seizure is not there. It's not if there was no traffic stop, then there was no seizure
there's
as a
no
result
seizure.
of a traffic
If you
stop.
didn't seize it, how can it be an instrumentality of the crime?
I don't know that the seizure makes something an instrumentality of a crime. I believe the car was always an instrumentality of the crime. The seizure
Which
is...
is counterintuitive here, because you say that it was an instrumentality of the crime, indicating that it was evidence of the crime, and if it was, then they would have had to seize the evidence, but then they turned it loose and didn't use it for evidence. So,
Well, law enforcement gets to determine in all cases what evidence they seize and don't seize. That's part of their investigation. So whether they seize something or don't does not change whether or not it's an instrumentality of the crime. And I think what makes this case different than the ones that you normally hear in a search and seizure situation are that we do have an arrest. This is not your normal traffic stop where then they say they do get him stopped for the headlight violation, and then they extend that stop. He's not arrested, and they extend in some manner that stop by bringing a drug dog out. That's not what we have here. We have him committing a crime in front of the officer arresting him, putting him in the patrol car, and then calling out a drug dog, and the dog going around the car and indicating, which gives PC for the eventual search. So that is the difference here between the cases that you normally hear. And it's our position that while defendant wants to argue that he should have been taken immediately to jail, someone should have been immediately called to take his car. His car should have been released to that person. There's no legal precedent, as the Court of Appeals found, or legal authority that indicates that's what had to happen here. And they're not arguing, as per the arrest of defendant, that he, didn't get his first appearance rights or wasn't taken to a magistrate forthwith. All of those things are not before you. So the real focus is there was an arrest, and then while they're investigating whether the flee and elude or because during the flee and elude, the officer sees defendant doing the things that we normally see, the furtive movements and everything. So he walks around the car and he calls a drug dog. But we also know that that sniff is not a search. So it's our position.
So can they go into a mall parking lot with a drug dog and just randomly walk around all the vehicles?
It's a good question because in preparing for this argument in the office, we did have that discussion, and I didn't delve deeply into that, but I did find there is some U.S. Supreme Court case law that says the exterior, you don't have an expectation of privacy in the exterior of your car. So if they do that and they're walking a drug dog and that sniff is not a search, possibly, I can't tell you definitively, but possibly that would be okay. I think there are some things out there that they say that there should be a connection to what they're doing that for, or a connection to a certain vehicle, but possibly yes, that they could do that, because taking that dog through that parking lot is not a search.
Counsel, a hypothetical for you. If once he was arrested, if they then took him to jail and they decided the next day that, hey, it might be a good idea to run a drug dog past his car, has the car been seized that entire time?
I don't think so, because the officers, everybody has left. I don't think there would be any indication that it's still under seizure, unless for some reason they taped it up with evidence tape or did something to indicate it was seized and couldn't be messed with. I don't think that it would still be seized at that time.
Why wouldn't you apply the same sort of analysis that we do with people? That when would a reasonable person believe that they could have the car taken away? I mean that the seizure ends when a reasonable person would have believed their wife would have been permitted to get in the car and drive it away.
I would have to say, because this is a car and not a person, and that belief is attributed to, that reasonable belief is attributed to the person. And as we've established, obviously, the car cannot have a reasonable belief.
Well,
I believe that's what.
Let's take it a step further on the chief's analysis. What if the three police cars with their lights on are there all night and the next day, and the wife drives up, has someone bring her over to pick up the car? Is the car seized? It's surrounded. They had to train the dog before they could bring it out, so they're all around the. You understand what I'm saying? Is that
It's getting a little far afield, but
well,
but yes.
Let's say
The dog had to be
5
born.
or 6 hours later, the dogs are all busy in there, but there's 3 or 4 cars around there. It wouldn't be reasonable for the wife to think she can get in the car and take it away. Would it?
And that's different. That's different than the question that Chief Justice Nuss had, where
I think
nobody's...
it's absolutely a different scenario, and that's what we're talking about. That's what I'm trying to ask. If you look at the surrounding circumstances and determine when it would be reasonable for someone with an ownership interest in that vehicle to take it back as their own and drive it wherever they want to, that it wouldn't be reasonable with a number of police cars. I'm not going to go get in a car that's surrounded by policemen and police cars and attempt to drive it away.
Well, and if I would add to your hypothetical, if we're going to speculate like that, I would also think that if the wife did arrive to get the car because she'd somehow been notified it was there, she most likely would have asked about it
And would she have been permitted while they were waiting for the drug dog? Would she have been permitted to drive it away while they were waiting for the drug dog?
While they were waiting for the drug dog, I don't know, but that gets.
Oh yeah, we
Well-
do. She wouldn't have been allowed to. They were waiting on the drug dog to sniff around the car, and if she showed up, they wouldn't let her drive that car away. You know they wouldn't.
But they also wouldn't wait 5 or 6 hours
No,
for a drug dog.
let's say it takes 45 minutes, and she shows up in 20 minutes.
Then I would agree they wouldn't release the car if they're waiting if it's in a reasonable amount of time.
And if they wouldn't have released the car within that hour or so, then why wasn't it seized during that hour or so if the owner could not have it? If you can't have, possess, and use something that the police have in their vicinity, why isn't that seized?
That is seized, and as the Court of Appeals found, and as the district court found, the vehicle was seized, but it was seized as an instrumentality of the crime the defendant was arrested for. And that, as I said earlier, we agree with the Court of Appeals in that finding. And
That conclusion
yeah.
of law.
And
what?
That conclusion of law.
Yes, yes.
so earlier questions that were taking you step by step as to when the vehicle was seized, my notes indicate at the beginning of the stop, and then I wrote through the arrest. And so you're now conceding it extended through that time until at least the drug dogs arrived and then performed their service. It was seized that entire time.
Yes. Yes.
But
Well,
you
just-
say lawfully. because-
Yes. I
because
mean,
it
our
was an
position is
instrumentality.
lawfully.
Just,
Yes.
just to be clear, though, you can't concede to a legally erroneous position.
You can't agree with it. You can concede and.
I mean, you can say you concede, but it has no effect if you're wrong as a matter of law.
Yeah.
True. And again, I mean, if you determine that the Court of Appeals was wrong as a matter of law,
Well, that's important because that's the difference between a question of law and a fact question.
yes. But again, we agree with the Court of Appeals. We think that this was analyzed correctly. We feel that this was not an illegal seizure. This was all resulted from an arrest. This is not your typical situation. And it's our position that the Court of Appeals was correct, and we would ask that you affirm that decision and ultimately the district court's decision.
Thank you, counsel.
Just briefly, Your Honors, I want to again touch on the idea that even if it was legally seized as the instrumentality of the crime, the argument is the scope of that seizure has to be limited to investigating that crime. And it wasn't. They continued the seizure to bring in something to investigate a different crime entirely that was in no way, shape, or form related to the crime of arrest. And that's the issue, is that they extended the scope of that seizure for something that was not permitted, that wasn't to investigate the crime of arrest. And that's the crux of our argument as to why the ultimate search was illegal, because the scope of the detention, the scope of the seizure was illegally extended beyond the scope, beyond the purpose for the arrest to begin with. And unless the court has further questions on that point, I would ask that this court reverse Mr. Parker's convictions.
Let me follow up with a question that came
Yes.
up in the last round with the state. What is the difference between a capture and a traffic stop?
Well, I would say generally for a fleeing and eluding, a capture would be a situation where perhaps they put out the spikes to stop the guy. In this case, Mr. Parker voluntarily pulled over in a Dillon's. He didn't pull over as soon as he probably should have, but he still voluntarily stopped. They didn't put up roadblocks to stop him. He voluntarily pulled over, and he wanted to pull over in a public place for his own safety. So the difference between a capture and a stop, while there may be a difference in certain situations, it's not really relevant for this case, because Mr. Parker did
Here's what
stop.
I'm thinking. He legally parks, he gets out of the car, locks it, he assumes control of the car, then walks away from the car and goes up to the police, and he's put under arrest. That's what we've got here. And no one disputes that.
Correct.
And so why wasn't he just captured? No different than if they had an arrest warrant for him and they were following him, and he stops the car, gets out, and then they arrest him after he's out of the car.
I guess my point is I'm not necessarily seeing why that distinction matters to the issue, because the car was still seized because he stopped.
It was
because
seized if he stopped for that reason. I mean, the record just reflects he stopped at the Dillons because there were lights flashing behind him, not because he wanted to go to the grocery store, right?
I didn't hear the last part.
What
of
the
that.
record tells us, he stopped in the Dillons parking lot because he saw red lights flashing behind him, not because he wanted to go to the grocery store.
Right. There's nothing to indicate that he was going grocery shopping. He stopped there, and he chose to stop there specifically because it was a public place for his own safety. He stopped because the police told him to. He should have stopped sooner. He didn't, but he did eventually stop at the direction of the police, and it was a seizure. The Court of Appeals found it was a seizure, and that finding was not, or concluded it was a seizure, and that conclusion wasn't cross-appealed.
And what about instrumentality of the crime? It also, according to the Court of Appeals, was the instrumentality of the crime.
Argument is, even if it was seized
No,
initially,
but I'm talking about as far as the seizure issue goes. The question was, he stopped the car, locked it, got out, relinquished control, walked away, and so you had an independent act of being arrested, like walking across the parking lot. But we have a Court of Appeals finding that that car was evidence of the crime. And the police typically can seize evidence of the crime even if it's not in your hands.
and I would agree with that. And but I guess our argument is, even if they did seize it at that point as evidence of the crime, if they were going to seize it and continue the seizure for that reason, they would have called a tow truck to come and impound it. They didn't stay there to seize that car as the instrumentality of the crime. They stayed there and waited that hour to bring in a drug dog to find evidence of a wholly unrelated crime. They extended the scope of the purpose of the seizure beyond what was legally permissible. So even if it was legally initially seized as the instrumentality of the crime, they could only extend that seizure so far as related to the scope of the purpose of that initial seizure, which would be to investigate for evidence of fleeing and eluding. They extended that seizure to investigate for evidence of a completely unrelated crime, and that's what the issue. That's where the illegal conduct, illegal seizure under the Fourth Amendment we're claiming occurred.
Kind of curious, what evidence would there ever be of fleeing and eluding when the officer has been following him, turns on the lights, and he stops?
See, that was my question I had as well. That I've had multiple fleeing and eluding cases. I can't imagine that there would be any evidence that could be found in the car of that, and I've never had a case where they've actually admitted the car into evidence. So the idea that it can be claimed to have been seized as evidence of the crime when that's never actually evidence in a fleeing and eluding case seems slightly incredulous to me.
Okay. Well, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement